Hey, hello, friends. This is Charles Bird, and you are watching the October 27th edition of Rant-Om Thoughts, where sacred cows are grilled and killed for your lunching and munching pleasure. And since it was so popular on the last one, we're gonna roast us some more pig. We're gonna roast us some more Alex Jones. Okay, Jacob Hornberger. He was he was the Mises Caucus favorite for president in the 2020 election. I voted for him in the California primary. Had the honor of meeting him in person at the Libertarian Party National Convention in Reno. He has written this very sober, cogent, rational, reasonable analysis of the Alex Jones case. And he says a lot of things in there that need to be said. And I am going to read these articles and offer my own reaction. To some of the things he says. Give my own input. So, and I will be linking the articles below, plus a couple of videos he did. And I also recommend you visit the Future Freedom Foundation website. There's which covers a whole array of topics. It carries columns by John Whitehead and Lawrence Vance, as well as Richard Ebeling. And the Foundation's YouTube channel, they have a show called the Libertarian Angle. It's usually Jacob Hornberger having conversations with Richard Ebeling, who is an instructor at the Citadel. So without further ado, let's start. I'm going to read these because most of you out there probably won't follow the link and read it. But this is stuff that needed to be said and stuff you need to hear. So here goes. All right. Alex Jones got what he deserved, Part 1 by Jacob Hornberger, dated October 17th, 2022. Whatever one might think about Alex Jones, it's difficult for me to understand how anyone can question the rightfulness of the multi-million damage awards that juries in Connecticut and Texas recently assessed against him. In my opinion, Jones got exactly what he deserved. For limited government libertarians, a proper role of government is to provide a judicial forum in which people can resolve their legal disputes. If someone commits a wrong, a tort in legal language, against another person, the latter has the right to file suit against the former for damages. We see this all the time, for example, in automobile crashes, where one person's negligence has caused the accident. The victim has the right to sue the driver whose negligence caused the crash and recover damages. If a tort is intentional, such as murder or rape, the victim has the right to sue for both compensatory damages and punitive damages. The compensatory damages represent actual damages suffered by the victim, such as medical expenses, loss of income, and pain and suffering. The punitive damages represent an intent to punish the malefactor by inflicting additional damages on him. In Jones's case, people filed suit against him for slander as well as intentional infliction of emotional distress, which has long been recognized by many jurisdictions as a tort. They also filed suit under Connecticut's Unfair Trade Practices Act. The legal question that still will need to be resolved is whether punitive damages are recoverable by the Connecticut plaintiffs, given that Connecticut libel and slander law permits punitive damages only with respect to the recovery of attorney's fees, but does not permit punitive damages in cases involving unfair trade practices. The lawsuits against Jones arose out of statements by Jones suggesting that the parents of the victims of the Sandy Hook massacre had made up their story and were just acting out the part of being victims who had lost their children. It's hard to get more slanderous than that. Jones's statements were clearly false and defamatory. Moreover, they subjected the plaintiffs to all sorts of attacks by people who believed that Jones was telling the truth. Jones claimed that his words were protected by the First Amendment, but it has long been established in the law that free speech does not include the right to issue false and defamatory statements about others. Yes, I know there are some libertarians who don't believe in libel and slander laws. They say that no one has the right to a good reputation and that people have the unfettered right to issue false and defamatory statements against anyone. I think those libertarians are wrong. I agree. But the fact is that the law doesn't support their position. Libel and slander have long been considered torts under America's system of jurisprudence, and Jones had to have known that. Jones hired attorneys to represent him in both the Connecticut and Texas lawsuits. Yet in the liability stages of the cases, the judges entered a default judgment against Jones. That meant that the plaintiffs automatically won that critically important stage of the case. In other words, the plaintiffs were relieved of any obligation to prove that Jones had, in fact, slandered them, with the issuance of a default judgment. All that was left was for the juries to assess the amount of damages. Some people might think that it was unfair or unjust for the judges to issue those default judgments against Jones. After all, a default judgment is when a person totally fails to answer a lawsuit against him. Here, Jones did answer both lawsuits through his attorneys. So why did the judges issue default judgments against him? In civil cases, both sides have the right to take the oral deposition of the other side. They also have the right to secure relevant documents and records from the other side. This process is called pretrial discovery. Jones, however, decided that he wasn't going to cooperate with the rules of pretrial discovery in civil cases. Not only did he refuse to appear for his deposition at the appointed time, he refused to produce requested documents and records. And it's not like the judges immediately issued default judgments against Jones. That's not the way things work in a civil suit, especially because a default judgment is such an extreme remedy. Instead, the judge will first order the party to produce the documents and records. When the party then refuses to comply with the judge's order, the judge will then consider extreme remedies, such as contempt or the entry of a default judgment. To avoid the imposition of such extreme remedies, all that the party has to do is comply with the court order and produce the documents and records. According to an article at First Amendment Watch, on Monday, November 15th, a Superior Court judge in Connecticut ruled that conspiracy theorist Alex Jones was liable by default in a defamation lawsuit brought by the parents of a Sandy Hook elementary shooting victim. Judge Barbara Bellis issued the default judgment after years of Jones's refusal to turn over financial and web analytics data that had been ordered by the court. In her ruling, Bellis criticized Jones's attorney for providing only sanitized, inaccurate financial records and showed callous disregard for her repeated rulings to provide complete analytics data. She found Jones's attorney's actions were not just careful, but constituted a pattern of obstructive conduct, requiring the most severe sanction of a default, which she called a last resort as reported by the Hartford Courant. By providing the pertinent documents and records, and by refusing to comply with the orders of the court, Jones has no one to blame but himself for the default judgments rendered against him. Then came the damages part of the trial. Jones and his attorneys exercised their right to participate in that phase of both cases. The Texas jury returned a verdict of $4.1 million in compensatory damages, which Jones considered to be a victory. The Texas jury also returned a verdict of $45.2 million in punitive damages, but it's unclear whether that will be upheld under Texas law. The Connecticut jury returned a verdict for $965 million in compensatory damages, which Jones considered to be a loss. Once the court enters formal judgments based on the jury verdicts, Jones has the right to appeal, but he cannot stay the enforcement of the judgments unless he posts a bond. He might be able to do that in the Texas case, but there is no way he will be able to do that in the Connecticut case, owing to the enormous size of the jury's verdict. That means the plaintiffs will be able to enforce collection of the judgment even while Jones is appealing. Jones's company, Free Speech Systems, which was also sued, has already filed for bankruptcy. My bet is that Jones ends up doing the same, which will automatically move the judicial claims over to a federal bankruptcy court. It will also most certainly mean that Jones will end up broke. Ordinarily, bankruptcy wipes out a person's debts. The big problem Jones might still face, however, is that if the bankruptcy court finds that his torts were intentional, it's likely that bankruptcy will not wipe out the judgments. Alex Jones Got What He Deserved, Part 2 by Jacob Hornberger, dated October 19, 2022. I received a couple of critical emails regarding my October 17th article, Alex Jones Got What He Deserved, which raised some important points about the Alex Jones case I wish to address. The first email stated, "First off, the fines you received were like if Jones killed somebody. The $965 million fine, even the $50 million fine, is basically the death penalty. It is also unconstitutional because it clearly violates the Eighth Amendment. He cleared the air about his stance on Sandy Hook and admitted he was wrong. That alone damages his reputation as a journalist. So Jones shouldn't be sued for defamation, and the fines should be drastically reduced. Also, there is no proof that Jones sent his supporters to harass the parents of dead kids. It's a kangaroo trial. The fines are unlawful and unconstitutional. It's a witch hunt to attack anybody who is a conspiracy theorist." The second email asserted that Jones had been denied the right to introduce relevant evidence at the Connecticut trial. Let's carefully examine these two critiques. There have been two trials, one in Connecticut and one in Texas. The plaintiffs in both cases were families who lost children in the Sandy Hook massacre. The plaintiffs in both cases alleged that Jones had defamed them by falsely alleging that they had made up the story about the massacre as part of a supposed conspiracy in support of gun control. Jones repeatedly made the claim on his internet show. The claim was believed to be true by his loyal followers, who proceeded to inflict all sorts of calumny on the plaintiffs. In the Connecticut case, the plaintiffs also sued for a tort that has been long established in the law called intentional infliction of emotional distress. They also sued Jones under the Connecticut Unfair Trade Practices Act. Under Connecticut law, plaintiffs in libel and slander cases are entitled to compensatory damages as well as punitive damages. But the punitive damages are limited to recovery of attorney's fees. For claims under the Unfair Trade Practices Act, there is no such limit on punitive damages. The Texas jury came back with an award of compensatory damages of $4.1 million. And then assessed punitive damages of $45.2 million. It is not clear yet whether the punitive damages will be upheld under Texas law, which limits the amount of punitive damages that can be recovered. The Connecticut jury came back with an award of $965 million for the several families who had sued Jones. These were entirely for compensatory damages. The largest award for an individual plaintiff was $120 million. The court as yet the court as yet to decide the matter of punitive damages under the Unfair Trade Practices Act. Let's now address the above described critiques. First of all, Jones was not fined in either the Texas or the Connecticut case. Moreover, the jury awards do not violate the Eighth Amendment case. That's because both cases are civil cases, not criminal cases. Fines are imposed in criminal cases, and the Eighth Amendment applies to criminal cases. This was a civil case. Moreover, the fact that a defendant might admit that he was wrong does not mitigate the amount of compensatory damages that a jury decides to award in a civil case. If I may pause here, I have seen video footage of Jones giggling and bragging about how those families will not see one dime of his money, or one dime of the money that his supporters will send him. That does not sound like a very remorseful man. It sounds like a sociopath. And that's what Jones is a sociopathic scam artist. Back to the article. Compensatory damages are intended to compensate for the damage suffered, not operate as a punishment. In other words, their purpose is to make the plaintiff whole. After hearing the evidence and carefully considering it, the jury obviously found that the plaintiffs had suffered an enormous amount of damage as a result of Jones's behavior, including the large amounts of threats and calumny that flowed from Jones's defamatory statements. Moreover, it doesn't matter that Jones didn't order his followers to do that. What matters is the amount of damages his actions caused. Moreover, it's entirely possible that the jury didn't believe that Jones was genuinely contrite for the suffering that his actions had brought these families, some of whom had to change homes several times to avoid the threats and calumny that Jones's followers were inflicting on them. During his testimony, in the damage phase of the Connecticut trial, Jones told the jury that he was done apologizing for his Sandy Hook statements. See? Told you so. With respect to the claim that Jones wasn't allowed to introduce relevant evidence at his trial, his biggest argument was that he wasn't permitted to talk about his free speech rights that are guaranteed by the First Amendment. But the judge was correct in her evidentiary ruling. It is long settled law that free speech does not encompass the right to issue defamatory statements about others. Everyone knows that is the law. Jones might not agree with the law, but that is quite irrelevant in a libel and slander case. All that is relevant in a libel and slander case is what the law is. And the law has been established for centuries that free speech does not entitle people to defame others. It is inconceivable that Jones did not know that principle of the law, but even if he didn't, ignorance of the law is no excuse. Secondly, the judge had already issued a default judgment against Jones. That was because Jones refused to comply with long-settled rules of pretrial discovery by refusing to turn over certain documents and records. Even after the judge ordered Jones to comply, he still refused to do so. When a party to a civil lawsuit refuses to comply with the rules of procedure and with court orders, the judge has the authority to impose sanctions. That's what the judge did by entering a default judgment against Jones. Such being the case, Jones's wish to talk about free speech rights became doubly irrelevant during the damage phase of the case. Yes, I know there are libertarians who oppose libel and slander laws. They say that they are inappropriate because they don't involve the initiation of force. That's why some libertarians also see nothing wrong when people commit fraud against others. They say that fraud, like libel and slander, does not involve the initiation of force and therefore should not be actionable. Some libertarians also say the same thing about unethical conduct, such as when a lawyer represents both sides to a legal dispute or takes money under the table from the other side. They say that because an unethical conflict of interest doesn't involve the initiation of force, it shouldn't be actionable. I couldn't disagree more with such libertarians. I believe that libertarianism involves a condemnation of more than just those actions that involve the initiation of force. I believe it also encompasses a condemnation of fraud, unethical conduct, and false and defamatory statements. Here, I definitely agree with Jacob Hornberger. Fraud is not a victimless crime. There are people who can be victims of unethical conduct. The Sandy Hook families were definitely victims of defamation. Do you know who also was a victim of defamation and took action against a major metropolitan newspaper for defaming him? And he was totally in the right. It was well within his rights to do so because they took a statement he had made about slavery and warped it out of context to make him sound like a white supremacist. The anarchist thinker Walter Block, who gives a lot of libertarians this notion that defamation law is not real. Mm-hmm. Yep. And a lot of the people who decry the Jones case, they had no objection at all to Jesse Ventura suing Chris Kyle, and then going after Chris Kyle's widow and children after Chris Kyle was killed. And then there's the whole Covington kid thing. Do you really think that he should have just lay there and take it while large media organs ruined his reputation and damaged it so badly he couldn't apply to the colleges he wanted to go to? Roll that around in your head. Okay, back to this. Suppose John accuses Peter of molesting a child. John knows that the allegation is false. His only goal is to inflict harm on Peter. The allegation is published in the mainstream press. Even though Peter denies it, people believe John because he is the president of a local company, while Peter is a local janitor. Peter gets fired from his job and is unable to find other employment. The anti-defamation libertarians would say, tough luck for Peter, but John has every right to do what he has done under principles of free speech. I say no. I say amen. I say Peter has the right to sue John for compensatory damages, to make himself whole. And I also say that Peter has the right to ask a jury to mulct John with punitive damages and punish him and to deter others from doing the same. In any event, Jones has the right to appeal judgments in both cases and ask the appellate courts to declare that libel and slander laws should be declared unconstitutional or invalid under principles of free speech. He has the right to employ the same arguments that anti-defamation libertarians make. I don't think he will get to first base. I think the appellate courts will instead continue to uphold the centuries of jurisprudence regarding libel and slander, but he certainly has the right to make the arguments. Let's address the kangaroo court allegation. Let's define what we mean by kangaroo court. It's a court where the outcome is preordained. For a good example of a kangaroo court, We need go no further than the Pentagon's and CIA's judicial system at Guantanamo Bay. That's a kangaroo court in its purest form. The trial is by military tribunal, not by jury. The military judges answer to their superiors, including the president. There is no possibility that they will issue a verdict different from the one that their superiors and the president want. In fact, the Gitmo system is revealing because it says everything about the right-wing support we see for what Alex Jones did to those families who lost children in the Sandy Hook massacre. How many times have right-wingers condemned the kangaroo system at Gitmo? How many times have they called for its termination? How many articles, podcasts, and speeches have they issued in the last 20 years condemning the Pentagon and the CIA for what they have done at Gitmo? I'd say rarely, if ever. That's because right-wingers love the Pentagon and the CIA. That's why you will rarely, if ever, see them devoting their articles, podcasts, and speeches to the dismantling of the Pentagon and the CIA and the restoration of America's limited government republic, as we have long done here at FFF, Future Freedom Foundation. For them, the Pentagon and the CIA are their untouchable gods. That's also why right-wingers hate the jury system, which I believe is one of the greatest judicial gifts our American ancestors bequeathed to us, both in criminal cases and civil cases. Right-wingers would much rather have a system in which right-wing judges or tribunals decide the guilt or innocence of people in criminal cases and decide factual disputes in civil cases. That's why they are condemning those jury verdicts against Jones in both Texas and Connecticut. As far as they are concerned, jury trials are kangaroo courts, but that's ridiculous. There is no way that jury verdicts in either case were preordained, or that the juries were involved in some sort of conspiracy to suppress free speech. Remember, those two jury verdicts against Jones in Texas and Connecticut were entirely independent of each other. The jury system certainly isn't perfect, but my experience has been that 12 regular people called at random from the community to resolve a criminal or civil case have a better sense of justice than any judge or tribunal, especially some crooked and corrupt right-wing judge or tribunal that right-wingers might cherish. Moreover, any notion that both the Texas jury and the Connecticut jury got together in some sort of conspiracy to put it to Alex Jones and his right-wing supporters is as ludicrous as Jones's fake and false conspiracy theory regarding the families who lost children in the Sandy Hook massacre. Acting independently, the juries in both cases found that Jones committed wrongs against innocent families who had lost children in the Sandy Hook massacre. Why shouldn't Jones be held responsible for his actions? Isn't a favorite mantra of right-wingers with freedom comes responsibility? Don't they often chide liberals for not taking personal responsibility for their actions? Why shouldn't Jones be held responsible for his wrongful actions? Why should he be given immunity from responsibility simply because he is a right-winger and conspiracy theorist? On to part 3. Alex Jones Got What He Deserved, Part 3 by Jacob G. Hornberger, October 20th, 2022. There are 5 additional points that have been made about the Alex Jones case that I wish to address, 4 of which were expressed in emails to me, and 1 of which was expressed in an article published today by Judge Andrew Napolitano. One, some of Jones's supporters say that the Connecticut trial was a kangaroo proceeding because the judge excluded matters that Jones wanted to tell the jury. but it's important to point out that a trial is not some sort of anarchist battleground. It is governed by rules of procedure and rules of evidence that have been developed for centuries of case law. Sometimes these judicial rules are codified into law by the legislative branch of the government. For example, see the Federal Rules of Civil Procedure and the Federal Rules of Evidence that govern trials in federal court. The same sorts of rules govern trials in state court, whether they have been codified into law or not. First-year law students are required to take semester-long courses in civil procedure and evidence. Every civil trial lawyer is expected to have a thorough understanding of both the rules of procedure and the rules of evidence. Woe to any lawyer who walks into a trial, especially in federal court, without having that thorough understanding. He will be skewered by the judge. Under the rules of evidence, a party cannot tell or show the jury whatever he wants. Any evidence he wishes to bring to the jury's attention must conform with the rules of evidence, and it must be offered into evidence under the rules of procedure. For example, if Alex Jones wanted to tell the jury, John Doe told me that the plaintiff didn't really move out of his house after he was harangued by my followers, as soon as Jones got the first 4 words out of his mouth, the opposing lawyer would stand up and object to the evidence as being hearsay, which is not admissible in trials except in very limited instances. The judge would sustain the objection and would not let Jones make the statement. This would cause Jones and his followers to exclaim, "Kangaroo court, Jacob! We should have the right to tell the jury anything we want." But that's not the way trials operate. The reason for the hearsay rule is that over centuries, courts have decided that the admission of hearsay into evidence results in an unfair trial and therefore will not be permitted. The same principle applies to other evidentiary matters. Some of Jones's supporters claim that the jury award of $965 million in the Connecticut trial is excessive. They could have a point. It's difficult to know for sure without having been there and seen what the evidence in the case was. The plaintiffs testified they were subjected to unbelievably horrific actions at the hands of Jones's followers. Some families had to move out of their homes because of the extreme harassment. One of Jones's followers even urinated on the grave of one of the children who was killed. Thus, there seems to be no doubt that the plaintiffs suffered enormous emotional and psychological damage as a result of the harassment they received. But the jury's award could only be for compensatory damages, not punitive damages. Whether the evidence supports the jury's damage award is a question of law for the trial judge and the appellate courts. If they find as a matter of law that the damages are excessive, they will reduce the award. But keep in mind the $965 million was spread among several families. The largest award for a particular family was $120 million. Some of Jones's supporters say that since he didn't order his followers to harass the plaintiffs, he shouldn't be held responsible for their actions. But that's not the way a tort action works. The law of torts holds that the defendant is responsible for the foreseeable consequences of his actions. This principle foreseeability was among the first principles we learned in torts class in my freshman year in law school. The case we studied was Palsgraf versus Long Island Railroad. The plaintiff, Helen Palsgraf, was waiting at the Long Island Railroad station in 1924. 2 men who were boarding before her dropped a package that exploded. That caused a scale on the platform to hit her. In a New York Court of Appeals opinion written by Justice Benjamin Cardozo, who went on to become a renowned justice in the U.S. Supreme Court, the court held that the defendant was not liable because it could not have reasonably foreseen the unusual sequences of events. According to the Wikipedia article on the case, the Palsgraf case is still taught to most, if not all, American law students in torts class. Were the actions of Jones's followers in harassing and abusing the plaintiffs after being convinced by Jones that the plaintiffs had made up the story about their children being killed reasonably foreseeable by Jones? I don't think there is any doubt that Jones would easily have foreseen that his blindly loyal followers would act on his false and defamatory statements by going after the plaintiffs. Judge Andrew Napolitano, for whom I have the highest respect, published an article in which he stated that Jones's statements are protected by the principles of free speech because he was only expressing an opinion. Napolitano is correct with respect to the general rule, which is that the expression of an opinion is shielded from an action for libel and slander. However, what Napolitano failed to acknowledge in his article is that there is an exception to that rule. The exception is as follows. If an opinion incorporates a defamatory statement of fact, the opinion goes out the window and the person is subject to a suit for libel or slander. Jones has unequivocally stated that the plaintiffs had made up their story about having lost their children in a gun massacre. The statement was false and clearly defamatory. Therefore, under the defamatory statement exception to the free speech opinion doctrine, the trial judges both in Texas and in Connecticut rightfully denied Jones's motion to dismiss. For a more detailed and fairly easy read exposition of this principle, including a defamatory statement exception to the defense, see the following article, The Opinion Defense, Can a Statement of Opinion Be Defamatory? Finally, I received an email from an FF supporter who informed me that he was never again going to support FFF because of my articles on Alex Jones. In a subsequent email, he stated the following. No children were killed at Sandy Hook. The families involved lied to the American people for money. They are despicable. I don't know what is alleged against Jones regarding the families, but they are the guilty parties in this case. I did not follow the trial like I don't read the National Enquirer. Needless to say, I was stunned. I responded by informing him that Jones had disavowed his own conspiracy theory during the Connecticut trial, and even had issued an apology for what he had done. I also sent him an article showing photographs of each of the children who were killed at Sandy Hook. His response to me, oh, yeah. I thought you were sending me pictures of dead children. Those children look alive to me. Show me the evidence of dead children at the scene. You won't be able to. I don't believe this is the Jacob Hornberger I've read for years. Something is fishy, like there is a gun to your head. I don't believe Jacob Hornberger holds the views expressed here. He has been compromised like Jones and scores of others. This man's mindset is reflective of many of Jones's supporters, who are clearly ready to blindly follow him and his baseless, false, defamatory, and despicable statements. It reminds me of the followers of Jim Jones. No, not Alex Jones, Jim Jones. At the next gathering of Alex Jones and his followers might want to think twice about drinking what he instructs them to drink. Now, here's the last paragraph. This is a very powerful statement. It needed to be said, and I am glad that it was said by someone as prominent in the liberty movement as Jacob Hornberger. Finally, for me, one of the most fascinating aspects of this controversy is the refusal of many of Jones's followers to condemn or even mildly criticize what he did. It's one thing to object to how the trials were handled or the size of the jury verdicts, but to remain silent or even supportive of Jones's horrific, despicable, and shameful conduct only goes to show the moral degeneracy of some right-wingers. Amen. Amen. Now, for those of you who are reacting viscerally to Hornberger's words and are attacking him, he's not the enemy, okay? He's not the enemy. He's not the enemy because he disagrees with you about defamation law. He's not the enemy because he believes Alex Jones had what was coming to him. I'm not the enemy either because I agree with Jacob Hornberger. Or that I believe his analysis was cogent and sober, and it's not fear mongering by some Trump sycophant shyster making the rounds on podcasts, scaring the bejeebies out of people to get them to donate to Jones's legal defense, which is what Robert Barnes is doing. Now, Jacob Hornberger is not the enemy, and he's not the enemy because he's expressing some strategic disagreements with the current leadership of the Libertarian Party. The real enemy is progressivism. The real enemy is neoconservatism. The real enemy is MAGA socialism, MAGA republicanism. Boil that down to its fundamentals. What you get is Bernie Sanders-style socialism, draped in the flag, wearing a red ball cap, with a gaudy cross hanging around its neck on a gold chain. Donald Trump is part and parcel of everything we're fighting against. I mean, he showed that recently by casually joking about how he would put whistleblowers and the reporters who protect them in prison to get sexually assaulted by inmates that are there for actual crimes. He's part and parcel of everything we're fighting against. And if you don't get that, then you are just as clueless as those poor souls out there driving alone in their electric vehicles with their face diapers on. And who was it that spent 4 years making excuses for Trump, defending him at every turn, sucking up to him, licking his loafers? Alex Jones. Who was it that defended Trump's airstrikes in Syria and his extrajudicial assassination of an Iranian flag officer, which is an aggressive act of war, which, if it happened to one of ours, our government would not take it laying down? Alex Jones. Who was it that defended Trump's banning of bump stocks, his push for red flag and ERPO laws, and the declaration of the COVID emergency? Said it was all four-dimensional chess. To trick up the libtards. Hell, he even coined that phrase, 4D, 5D chess. Alex Jones. And who is it who's going? Who is it that is going to support, Trump in his second term, doing that to whistleblowers and journalists, doing that to Julian Assange if he gets extradited in Trump's second term? Alex Jones. Because he is a Waylon Smithers type sycophant for Trump. Mm-hmm. So much so that Jones ignored, at best, and at worst, just brushed it off as fake news, Trump's connection to Jeffrey Epstein. Roll that around in your head. If Alex Jones did not exist, the organized evil or the regime or the deep state or whatever you want to call it, I call it what it is, organized evil, would have had to invent him. They used him in the thousands they used him and the 9/11 Truth Movement in the thousands to discredit the anti-war movement. They used him in the 2010s, to discredit critics of the Obama administration and to discredit the Second Amendment movement. Then they used him during the Trump years to keep his following on the GOP plantation. If he were the genuine article, he would have been as tough on Trump as he was on Bush. And now they're using him, and they're using Kanye West, a mentally ill man, as laser pointers to misdirect us, to get us staring over here when we should be looking over there. And what's going on over there? An increase in police brutality and police corruption, a slide towards authoritarianism, of which the COVID regime was just a brief foretaste. Looming economic eclipse, and the threat of a third world war that we probably will not be able to win. Where both sides have in their arsenals literal doomsday weapons that could destroy the world many times over. Get your priorities straight. If I didn't love you, if I didn't care, I wouldn't be raising those concerns. I wouldn't have read what I just read to you right now. If I didn't care, I would be sitting right here laughing my head off at all you lemmings out there Excuse me. And all you lemmings out there, and all you keyboard commandos and couch potatoes being led over the edge in that direction, I wouldn't be telling you you're on the wrong path. All right, on to another fun group of people, from Jones cultists to Nathos. What is NAFO? NAFO is an acronym for North Atlantic Fella Organization. These are trolls on Twitter who claim they're fighting Russian disinformation. Actually, what they do is they mount these harassment campaigns against anti-war Twitter users, and they do so while hiding behind pictures of cartoon dogs. So, just for fun, I dropped three tweets critical of them, just to attract them, just so I could just mass auto block them. Best 3 hours of my life spent like playing Space Invaders with my delete button. I think I'll link the threads below in the description. Just so you know what nasty characters I've had to deal with, and yeah, you know, some of them might be real, some of them might not be. I suspect that they're the ones that have been reporting my stuff on Twitter, though. There were like 2 or 3 occasions where I had my account locked and I had to delete some random tweet from like 2 years ago, or I'd get some email from Twitter telling me that somebody had reported one of my postings as being in violation of some German hate speech law, and that even though it didn't violate that law, they still had to notify me anyway. Uh, yeah. But you know what? I'm still going to be anti-war. I'm still going to yeah. I'm still going to be out there first Friday of each month, calling for saner heads to prevail in this conflict, even if I end up being the only guy out there on the sidewalk. Okay, I watched the 10-hour miniseries about Jeffrey Dahmer on Netflix. Evan Peters, I think, did a hell of a job playing the title role. He's a very versatile actor, kind of like Johnny Depp. Uh, I can see him. I can see him moving on to some really big things in his future. The show does an excellent job of chronicling how incompetent law enforcement and a ridiculously, ludicrously judicial system just dropped the ball repeatedly and basically enabled him. You know, they I mean, one time he got popped for child molestation, and his punishment was 1 year, not in prison, but in jail. And they gave him a work furlough so he could keep working at his job at a chocolate factory. The only problem I had with the show was the portrayal of Jesse Jackson. I mean, the real life Jackson showing up there, his motivations wouldn't be so noble. It would have been purely ulterior, and it would have been all about self promotion, because that's what he's been about for years and years. Self promotion and making money off of this and that. After watching Dahmer, I binged it in 2 5-hour sittings. I went on to some lighter fare. I watched Rob Zombie's reboot of The Munsters, and it was lighthearted, campy fun. I understand why some people were disappointed. The negative reviews tend to come from either cinema snobs who look down on Rob Zombie's work, or from people who are fans of Rob Zombie but were expecting a typical Rob Zombie feature with all the over the top gore and the F word being in every being uttered at least once per line and all that. But it was PG rated. It was campy. It was goofy. I could imagine my mother enjoying that movie. All right. Almost an hour long. That's good. Well, I had a lot to say. So anyway, I love you all. I mean it. Keep your BS detector turned on. I'll see you next time.